Good evening. Welcome to the Rent Control Board meeting. I'm going to call it's February 11th, 2021, so I'd like to call our meeting to order. Would the secretary please take roll?
Yes. Commissioner Tarosis.
Here.
Commissioner Phyllis.
Here.
Commissioner Foster.
Here.
Vice Chair Duran.
Here.
And Chair Sultan.
Here.
All present.
Okay, great. So at this time, I'd like to note that anyone wishing to address the board on a specific item on tonight's agenda should have contacted our board secretary prior to the meeting. We will make sure to recognize the speakers and arrange to have them speak when it is their turn in the queue. All right, may I have a motion to approve the minutes of the board's last meeting?
So moved.
Do you have a second?
I'll second.
Excellent. So I think we had a motion from Commissioner Foster and a second by Commissioner Duran. Would the secretary please take a roll call vote?
Yes. Commissioner Phyllis.
Yes.
Commissioner Foster.
Yes.
Commissioner Tarosis.
Yes.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
Minutes been approved. Now moving on to special agenda items. Do we have any brief announcements, commendations, awards, or introductions of special guests?
Yes, I have
Okay.
I have a couple of things this evening. First, I'd like to welcome General Counsel Allison Regan. As I mentioned at the last meeting when the board announced her appointment, Allison worked for the last 16 years at the City of West Hollywood, where she advised all of their departments on municipal law issues and spent a good deal of her time working with their rent stabilization department and commission. She joined us about a month ago, and she jumped in with both feet, and we're very, very happy to have her on our team. So welcome this evening, General Counsel Regan.
Thank you so much. It's a pleasure to be here.
I also wanted to mention that both the city and state have extended the eviction moratoria through June 30th at this point. We'll hear more about the state extension of the eviction moratorium from Brian Augusta later in the meeting. For more information about the city's eviction moratorium, people can either contact our office at 310-458-8751 or the city attorney's office at 310-458-8336. Or there are also extensive materials about the eviction moratorium on the city's website. And finally, I just wanted to mention that the city has contracted with the Strauss Institute at Pepperdine University to offer mediation services to tenants and property owners in Santa Monica who are interested in working out some sort of settlement agreements or arrangements around non-rent payment issues. So anybody who's interested in looking into that can find information by visiting Pepperdine's website at law.pepperdine.edu and then follow the links to the Strauss Institute. And that's what I had this evening.
Thank you. Do we have any public comments scheduled for tonight?
No, we had no requests for public comment.
No requests for public comment. Okay. That being the case, we'll move on to continued business. We have It's an application for a removal permit. This is item 8A, application for a removal permit at 2024 19th Street and 1819 Pico Boulevard. Hold on one moment. So I think we have, I'm forgetting, excuse me, this is my first night sharing. I believe we have, we do the staff report first, right? Okay, thank you so much. Could we have a staff report on this item, please?
Good evening, Commissioners. I apologize that I've turned off my video because I'm having Wi-Fi problems. I want to first make sure that you're hearing me fine and clear. Yes, great.
Yes, we can hear you.
Thank you. Commissioners, Santa Monica's rent control law sought to preserve affordable housing by precluding the demolition of rent control units unless the board has granted a removal permit. One of the reasons the board can grant a removal permit is so the existing rent control units can be replaced with new ones if at least 15% are restricted as affordable to low-income household. CCSM, Santa Monica's principal affordable housing developer, bought 2 adjacent parcels at the corner of Pico and 19th. The 2 parcels had a total of 8 rent control units, but only 3 of them are occupied. CCSM approached the 3 households and signed relocation agreements with them in which they were offered either monetary relocation as set under state law for tax credit projects, or if they were low income, to relocate to another CCSM affordable unit while the project was being built, and then move into a new rent control unit in the new affordable housing project, all with the same MAR that they're paying for now, adjusted annually by the board. CCSM then applied to the board late last year for a removal permit to build a 48-unit, 100% affordable housing project, with 8 of the affordable units designated as rent-controlled to replace the 8 to be demolished. Days before the board first heard this matter in December, the tenants of Unit E at 2024 19th Street obtained legal counsel and contacted the board just prior to the hearing to object to the board's approval of the removal permit. They didn't argue that the project doesn't meet the charter's requirements. Instead, they argued that the relocation agreements signed were invalid, that the tenants had not received the documents in Spanish, the language in which negotiations had taken place, and that CCSM was reneging on promises it had made to the tenants. The board continued to the matter to allow the parties to negotiate a settlement of their disputes, and CCSM then asked the board to continue the subsequently scheduled hearing in January to allow additional time to reach a settlement. During that time, the households of the other 2 units moved to new affordable units in other CCSM properties. But the tenants of Unit E continue to voice their objections and have not reached a settlement with CCSM. Although they had initially stated they'd never received Spanish versions of the relocation agreements, CCSM submitted the Spanish version and a Spanish summary of the agreement signed by the parents of the households. The 2 adult sons, however, had not signed either document. For that reason, the tenant attorneys continue to argue that the agreement is invalid. They also argue that it fails to satisfy the requirements for a buyout agreement because it fails to inform the tenants of the right to refuse the offer or to seek legal counsel. They demand a new agreement, but the parties have not been able to settle on one because it appears that they have yet to settle on where the tenants will relocate to. The tenant attorneys had also been objecting to the documentation required by CCSM to prove the tenant's low-income status, but since the initial hearing, those documents have been submitted, and CCSM staff has informed us that the households do in fact qualify as low-income. So it appears that the main objection by the tenant attorneys is that CCSM has offered the tenants a 2-bedroom affordable unit during construction of the project, which, even though substantially larger than the tenant's current unit, is not a rent control unit, and therefore the tenants will lack statutory eviction or rent protections beyond any contractual ones they arrive at with CCSM. CCSM has said that any agreement with the tenants would preserve their existing MAR and would abide by the eviction restrictions of rent control. It should also be noted that the Santa Monica Charter also imposes the same eviction restrictions for non-rent control units through Chapter 23 of the Charter. In its response, CCSM has stated that a 2-bedroom rent control unit did become available in late January when the tenants moved out, but that it requires substantial rehabilitation, which may take a maximum of 6 months. In the meantime, they have offered the tenants to either move into the original non-rent controlled affordable unit that they had been first offered, or to move into other market rate rent control units in the same neighborhood where CCSM would subsidize the rent so that the tenants continue to pay the same MAR as they are now, and then they could move into the rent control affordable units in 6 months or so once it's been rehabbed. CCSM has stated that it would also give them additional monetary compensation for that second move. To date, however, the tenant attorneys have rejected these options. It is clear that the parties have yet to settle their dispute. Since the relocation agreements are for a voluntary move-out, these differences will have to be settled before the project can proceed and the existing structures can be demolished. Relocation is set under the municipal code, not the rent control law, as well as under the state's requirements for a tax credit project. However, the issue before the board in this application is whether CCSM has met the requirements for a removal permit under the charter. The charter directs the board to grant that removal permit if the owner seeks to demolish existing rent control units and replace them with new ones if at least 15% of those units are deed restricted. Here, CCSM seeks to do just that, replace 8 rent control units with 8 new ones within a 48-unit newly constructed 100% affordable housing project. And because CCSM has met and indeed exceeded the charter's requirements for a removal permit, staff recommends that the board grant the permit and adopt the proposed findings of fact and conclusions of law. Thank you.
Thank you so much. Do the commissioners have any questions about the staff report?
Yes, but
No.
I'm going to save it for discussion. All at
Okay.
once.
So I believe it is time to move on to speakers. We have a request to speak for 4 different speakers, 3 on behalf of applicant CCSM and 1 on behalf of the tenants. The CCSM speakers have 5 minutes, and they are Jesus Hernandez, Brittany McClintock, and Dr. Michelle Folk. Mr. Hernandez is the applicant, Ms. McClintock is an attorney, and Dr. Folk is a relocation consultant. So I believe we can start with Mr. Hernandez. Is he ready in the queue?
No, actually, next on the line we have Brittany McClintock and Dr. Michelle Folk. However, Jesus Hernandez has not joined the queue.
Okay. So let's start with Ms. McClintock. Are you here?
I am. Is everyone able to hear me?
Yes, we can hear you. Thank
Can
you.
hear
You have 5 minutes to share with the other speakers.
Great.
Thank you so much.
CCSM has been working towards an agreement terms amenable to both sides, namely Unit E and Unit E's council. As of today, we have at least what CCSM believes to be a tentative agreement or terms that have been tentatively agreed to, at least to the material portions, such as where the relocation, where the temporary unit will be located, contingencies for if a refurbished 2-bedroom rent-controlled unit does not become available by a certain time, along with the right of return to the 1819 Pico location. The parties have worked through an actual lease agreement for the interim affordable units, and basically the temporary units are going to be split into, as mentioned in CCSM's letter, an interim affordable unit that the tenants of Unit E would occupy for approximately 6 months, while a 2-bedroom, 2-bathroom affordable unit is rehabilitated and remodeled Once that unit becomes available, the tenants would be able to move to the alternative affordable unit at the same building. And then once the development project is done at 1819 Pico, they would also have the option to move there, assuming they do qualify at the time of lease up. The parties have agreed to it is at least my understanding that as of this evening, the parties have agreed to the monetary demands of the tenants, which include a $40,000 payment for the relocation, as well as contingency payments for if the secondary temporary unit, the 2-bedroom, 2-bath, is not completed by August 31st, 2021, which includes monthly payments for the period that it does go over and beyond that time until it is ready or until the 1819 unit redeveloped property is ready. Barring a few remaining word or semantics issues, it's my position that the parties have reached a tentative material agreement as to the significant terms of getting these tenants relocated into the temporary housing until the development project is completed.
Thank you.
That would no problem.
Thank you so much. So the unit that they're potentially going to be relocated to, this is where there's a 1-bedroom unit that they would be in until the 2-bedroom unit is fully remodeled?
Correct. That's correct.
Okay.
And they're both located in the same building. They're both rent controlled.
Okay, yeah, that's what I wanted because I know that was an important issue for the tenants. Do other commissioners have questions for Ms. McClintock? Looks like Commissioner Terosas does.
Thank you so much. I just have a quick question because I think I know the answer given the staff report, but you said, the tenants will move back in on Pico assuming they income qualify. So if they don't income qualify at the time of lease up, is that when the amount of money paid to them for relocation benefits is triggered?
No, they do not. They do not wish to be bought out. So what we have worked out with opposing counsel is that they would be able to stay in the unit that they are then residing in, the rent-controlled unit that they are then living in. They would have that option to just continue their tenancy there.
Got it. And so just to make sure that we're all very clear, the rent-controlled unit that you're moving them to is going to be at the same rent that they're currently paying, correct?
Correct.
So therefore, they'd still, regardless of whether they're in their current unit or in this new unit, they will be subject to rent control at the same rent that they would have paid, had they not moved.
Correct.
Okay. No further questions. Thanks.
Thank you. Are there any other questions for the speaker, commissioners? Okay. Thank you so much, Ms. McClintock. I think we will move on right now to Dr. Michelle Folk, if she is ready. I hope I have the gender correct.
Hi, good evening. Actually, CCSM asked me to be available in case any of you had questions about the original agreement or how that, what those circumstances were.
Great, thank you. Do commissioners have any questions at this time for Dr. Folk? Oh, I see a question by Commissioner Foster. Please.
Yeah, since she mentioned it, the only thing I was going to bring up is I was going through I had to break out my Rite Aid $1.99 cheaters for this one. The extensive pages of the email exchanges. First of all, I'm really sorry for all the parties involved that it had to come to this. This looks to be exhaustive and exhausting, and I'm really sorry that you all had to go through this on both sides. But we were quoted in one of the emails saying that we had asked, members stated they could not in good conscience approve the permit without more documentation, including signed agreements for all tenants. That was not, in fact, what I, for one, had asked. What I'd asked was that I see that the documents were indeed in Spanish and English for myself because they were not exhibits. It was not that I was asking to see all 4 signatures or anything else, because that is not what is at issue for the board. It really concerned me, though, that there were tenants who seemed unclear or even potentially unclear, whether it's due to the flow of information between the 2 parties or the understanding that, or lack of understanding that could come with any language barriers. And I've been completely satisfied that those burdens were met to begin with and still seem to be. But I did just want to mention that I'd seen that in the correspondence and wanted to address it.
I do actually have an additional question for Dr. Falk. There were allegations that the tenants, well, first of all, that only 2 of the tenants, were asked to sign these relocation agreements or provide information about the relocation, and that also the tenants weren't provided the required buyout disclosure form with all the all the language in it that we require under Santa Monica law. So I'm a little bit concerned if it's CCSM's general practice not to provide all the legally required kind of disclosures and information before this type of buyout. So I was hoping you could comment on that.
Sure, and I can't comment for other projects, but this one that we were involved with, the tenants did receive the disclosure from the city's format in English and Spanish.
Okay.
I'd like to further add, we were confused by the statements originally about everything being in English, and they didn't understand what they signed, and the communications weren't in a language they understood. We had a bilingual agent, and actually she's a manager, Spanish, English agent that communicated with them every time. She met primarily with the wife, although the adult son, one of the adult sons, was at every meeting. The other adult son was medically unavailable, and we couldn't have had him sign an agreement. We realized that maybe the level of understanding of a complicated agreement that had so many different pages and was very legal sounding might be difficult, which is why we had that summary statement prepared for them to point out the highlights of the agreement. That was also in Spanish. And so we felt very comfortable when the couple indicated they would be moving as a household, that both sons were dependent on them. One son had no income, the one that was medically unavailable. The other son earned about $900 a month. And so he was at every meeting, never voiced an objection, never said, I don't want to do this. And I think that's why we were very confused when the letter was produced at the 2 hearings ago. So again, I can't comment on when CCSM does on other projects. I have faith they do things by the book, and the tenants absolutely received the disclosure statement or notice.
Looks like Ms. Condon has a comment to make.
Chair Tolton, I just wanted to mention that Mr. Hernandez has joined us from Community Corporations, so you may want to see if he wants to add anything to the questions that the commissioners have asked.
Hi, Tracy. Hi, everyone. This is Jesus with Community Corporation. I think our attorney, Brittany, has covered kind of the status of where we're currently at. But I'm here to answer anything else that may come up. And obviously, Michelle is here as well. Thank you.
Are there any other questions for amongst the commission for any of the speakers?
I actually
Do we have other speakers? Do we have other speakers besides CCSM?
Oh, yeah, no, I guess I was asking if we had any more questions for these speakers.
Did Mr. Hernandez want to make a statement, or was he allowed to make a statement?
Yeah, Mr. Hernandez, did you want to say something else?
No, I think we are, as Brittany indicated, we're actively negotiating with the family and the family attorney to resolve the matter. I think we're awfully close now. I know there's some stuff that happened in the past that we could have made better and improve on our process. I think we stand and agree that the documents were signed by the family, and it was voluntary, and we tried to do everything we could to ensure that the family understood the process. It's unfortunate we're at this point, but I think our council, along with the family council, have really got us to a point to kind of bridge that pass and to move this forward, because obviously, there is a lot of stake for both the community corporation, the city of Santa Monica, as well as the city has invested heavily in seeing the affordable housing development built. Obviously from our side, we only bought the property after we were able to negotiate these voluntary buyout agreements. If not for that, the acquisition would never have occurred. So we made sure that we arranged the acquisition of the property to coincide with voluntary buyouts. If not for that, this would not have moved forward past that. So that's why we stand firm in our belief that everything was done, as Michelle said, above board. But the family may see it differently now, but that's water under the bridge now, because we're awfully close to settling on an agreement to ensure that the family continues to reside in rent-controlled housing, which was one reason we stopped the acquisition, is to ensure that the families who resided at the property continue to reside in rent-controlled housing long-term. And as indicated earlier, 2 of those 3 families have moved out already into our existing rent-controlled stock. So I think that's a success already. And obviously we'll have the right to come back if the income qualify for the new property. But again, I'm just here for any questions that may come up. Thanks for your time.
Mr. DeRosas has a question for you, Mr. Hernandez.
Yeah, I have a question. Mr. Hernandez, I'm not sure if you're on the development team, but can you confirm for me that this project received 9% tax credits?
It has, yeah, and we are under the clock on this one. The tax credit agency gives us essentially 6 months to pull the building permit, to negotiate with our investor for the low-income housing tax credits with an investor, other permanent financing. So we have an April timeline to pull and agree on terms with the various parties. And obviously this is one piece of all that.
And can you explain for me and everyone else the competitive and limited nature of these tax credits?
It's a competitive line application that we have to compete with other developers either across the state or across the county, and then at Los Angeles across the city of LA. This is an application that incentivizes local funding from the municipality, and the city of Santa Monica has really stepped up to commit to this project to ensure that it receives an allocation of low-income housing tax credits. We are able to leverage about 60% of financing from the tax credit program, and Santa Monica brings in about 30%, and we have 10% of other financing. So the city of Santa Monica is heavily invested in this project and has worked to ensure to us that we receive an allocation of low-income housing tax credits by providing soft financing to the project.
And Mr. Hernandez, if you were to lose these 9% tax credits because you didn't get the permits in time, would your project be able to go forward?
It'll jeopardize the project at a minimum. It would jeopardize the health of the organization. The tax credit agency penalizes entities that cannot meet the 180-day or 6-month period, and it jeopardizes us future applications for up to 2 years. So we, as an organization, rely on developer fees earned from developments like this to keep our doors open, to keep staff, our lights on. So it's really pivotal and important that we are able to meet these timelines, because it will jeopardize at a minimum the project and the health of the organization long term.
All right, thank you. No further questions.
Okay, not seeing any further questions from Mr. Hernandez among the commissioners. I guess we will thank you for your commentary, for your providing us with this information. And we're going to move on to the tenants' legal counsel, Mr. Kornarens. Mr. Kornarens, are you here and ready to speak?
Yes, thank you. Thank you for recognizing me. I'll try to keep my comments brief, and I'm willing to answer any questions you may have. The tenants at Unity continue to object to the application, although they absolutely agree that we're much further along than we were 2 months ago or even 1 month ago. We seem very close to an agreement, and although I disagree with some of the factual assertions that have been made about what happened beforehand, I don't think it's productive to have another round of that when what we're trying to do is to move forward rather than look backward, and we do seem closer. The reason why we're still objecting, and we believe it should be addressed now, is the staff report correctly says since the relocation agreements, this is second supplemental report, since the relocation agreements are for a voluntary move-out, these differences will have to be settled before the project can proceed and the existing structures are demolished. Staff recognizes that, and that's consistent with Charter Amendment 1803T2. And it does not talk about removing it where an applicant seeks to develop the property. It does not say that. It says if the permit is being sought, so the property may be developed, which means you have to have a viable project. That's acknowledged. And it's also acknowledged that unless all of the tenants voluntarily leave, we don't have any project whatsoever. Now, our goal was not to obtain a buyout on behalf of our clients. We were offered that, we turned it down, and then we turned to more productive things. We now do have something that is very close to being signed, although I can't tell you whether the changes I received at 6 p.m. tonight and 6:10 p.m. tonight cover everything that's been discussed. I'm hopeful that they do, but I can't tell you that right now. So we're faced with a situation where they put the cart before the horse. They didn't get all of the signatures. We continue to maintain that what occurred before wasn't compliant, but again, we're trying to get past that. I want to explain what some of the issues are so that you can see this in something other than an obscure vacuum. The tenants have agreed to temporarily relocate to an upstairs unit that is 1 bedroom. The reason why upstairs is relevant is because it's a walk-up, and Ms. Gomez has been found permanently, partially disabled in both knees. So she'll have to get up and down the stairs for 6 months on her own, and she's agreed to do that. CCSM has graciously agreed to use commercially reasonable efforts to try to put a chairlift in for her, which is wonderful, but it creates some time pressure. They ultimately cannot end up on the 2nd floor of a 1-bedroom unit without a lift, without an elevator. It won't work. Therefore, the next unit, which is Unit 101 at 1959 Cloverfield, is really the end game because the return to the PICO project is not assured because they have to income qualify at the time. And the one remaining worker in the household, the one who makes real money, works for a wedding facility place called Calamigos Ranch. We're in the middle of a pandemic. People are being laid off. We cannot be assured that they will make enough money to income qualify. And CCSM is unwilling or unable to pre-qualify them. That's why a lot of emphasis is placed on this Unit 101. We've seen Unit 101. The tenants have seen Unit 101. It is acceptable once all of the black mold is removed from the unit. And that's what we're working on right now, coming up with acceptable language that allows CCSM to do its job while protecting the health of the tenants. So our clients want to work this out. They want to be able to move. They agree that the rent will be the same. They agree that it's under rent control. They're operating under the presumption that there's a very good chance they will never be able to return to their current home. They hope they're wrong, but they don't know one way or another. So they have to look at this mold-riddled unit now and trust CCSM, but we have to document it, and that's why this has been a bit convoluted. So we're very close to reaching an agreement, but we're also looking at some alternatives. Counsel for the tenants had drafted a declaratory relief lawsuit a month ago, which we were going to file until the meeting was continued. And that gave us another month to talk. We've held off filing that suit because we're making such good progress and we've been asked not to. But at this point, we're in a bit of a quandary, and I actually need the board's help to work through this. I know that's not your job, but you are here to protect tenants as well as protect CCSM. If we don't file and this permit application is granted, and I think improperly under my interpretation of the charter amendment, although staff disagrees with me, because we're not going to have a project because they're not going to voluntarily vacate, CCSM is going to seek a permit and process the project, thereby jeopardizing my clients because they'll have to move to an apartment they cannot stay in long term for sure because of her physical condition and an uncertain resolution with respect to Unit 101. If we have the signed agreement, we're willing to take those risks. We have to. I mean, there's no other choice in the matter other than to litigate, and they obviously prefer to live their lives. So if you unconditionally grant the removal permit tonight, we have to file the lawsuit. We'll ask the court to intervene to stop this process. And what we think ought to happen.
I apologize. This is Board Secretary Alvin Ho. Mr. Kornorens has reached his 3-minute limit. Would you like to let him continue?
Yeah, let's let him finish what he was saying.
Yeah, thank you. It'll be very quick. One way to do it would be to grant it, but condition the approval of it on Community Corps' execution of the relocation agreement, just like you're conditioning it on on their obtaining a permit and recording it. So a conditional grant. Another one is to grant it and give administrative staff this discretion to do the administrative paperwork to do the removal permit, provided we have the agreement signed. Another one is to deny it and put it over, but I understand that there's time sensitivities involved, and we feel like if we can't get it done in the next few days, we're not going to get it done at all, in which point there won't be a project, which would be regrettable for everybody. So we're requesting a little bit of flexibility because we can't risk that CCM will pursue the permits and try to evict the family, and we're not going to negotiate with a gun to our head. So we have to go to court and ask the court to find that the relocation agreements are not valid, and we believe we would prevail. Thank you.
Mr. Kornorens, could you clarify why it is you think that Section 1803 of the Rent Control Charter Amendment doesn't permit us to grant this removal permit? I'm just trying to understand your reading.
Yes, it says if the permit is being sought so that the property may be redeveloped with multifamily dwelling units, and staff characterized that in his presentation as seeks to develop, may be developed, assumes that it's actually a possibility that it could occur, and here the project is specifically subject to, the financing is subject to each tenant voluntarily relocating, and that is an impossibility without the consent of the tenants. The tenants don't consent. We know that 2 of 4 have never signed. We know that the other 2 of 4 dispute the facts and circumstances. That's why. There has to be a possibility, and it's an impossibility.
I think I understand your reading. Thank you. Any other questions among the commissioners for Mr. Kornorens?
So I just have a quick question. Mr. Kornorens, you're suggesting that we potentially grant this based on community court, predicated on community court's filing of the relocation agreement. Is that what you're suggesting we do?
The execution of the relocation agreement by community core and the tenants. And you can even set a deadline because we're going to get it done or not get it done very, very shortly. We're very close.
And you believe it's in the best interest of your clients to issue a lawsuit, to file a lawsuit if we were to grant this removal permit tonight?
Yes, because how do I say this? There are still issues based on our conversation of today. And these are supposedly under Evidence Code Section 1152. I can get into them, but there are some issues still. But I haven't read the documents that came in at 6 and 6:10 p.m. tonight. I don't know what the rewrite looks like. Ms. McClintock is professional. The negotiations have been very detailed, but very cordial. So I'm fairly optimistic, frankly, and no, it would be a disaster for everybody if we felt like we had to file a lawsuit, and that's why we held off for so long.
Okay.
Oh, it looks like Commissioner Duran has a question for the speaker.
Oh, no, I'm sorry. I have a question for council, but if there's more questions for the speaker, they can certainly go.
Okay. Thank you, Mr. Corners. I don't see any more questions for you, so I think we should. Thank you. Do we need to officially move on to deliberation before Steve's asked his question of council? Yes? Okay, I'm thinking. Okay. So let's move on to deliberation now.
I'm sorry, Chair Sultan, this Board Secretary Alvin Ho again.
Oh, thank you.
Sure, we did have a late speaker request on this item, if you'd like to allow it.
It's fine with me. Is it my discretion? Okay, sounds like it is. Yeah, let's hear the late speaker.
All right. Up next, we have David Watley, public comment on item 8A. Mr. Watley, you've been unmuted.
Hi, good evening. This is David Watley, and I know a few of the people on the board. It's been a while, but so what actually caught my attention with regard to this particular item is that it involves Spanish-speaking immigrants, which is, I know many people on the board are aware, is a policy issue that's, very important to me and that I've done a lot of advocacy work about in the past. So I did want to, I did feel sort of moved to, make these comments. And then also with regard to the applicants, I think some people on the board may be aware, I actually used to live in another property of the applicants in the city, and I participated in the city's, affordable housing program. So I just wanted to say that the building I actually lived in was actually a rent control property as well that was purchased by the applicants. And in that instance, the tenants were able to keep their original lease and their original terms. And that was for, that was also, it was bought with, federal funds, federal tax credits, city trust funds, all that stuff, right? I don't know what CCSM's financing this particular building with, but it sounds like, they've gotten a lot of government money in the past and they're doing the same with this, right? With this purchase. So my thing is, why can't they apply that same right to keep the same terms of the lease to the long-term rent control residents that they did in the building I lived in, right? For those rent control residents, why can't they apply that same principle to the tenants that are in this particular, in this Pico property? And, I know that it's kind of race is always a touchy issue, but I'm trying to analyze this, and what I do notice is that I lived in the Wilmot district of the city, which is less diverse. The neighbor that I spoke to that he was able to keep his lease was a white male math professor at a university, local university. And then we have in the Pico, they're not getting the same privilege of keeping their same lease, exact same lease that they had before Community Corps took over, right? And this is like a protected class, Latinos, immigrants, Spanish speaking, I don't know. I think that in the environment that we're in, that's something that needs to be perhaps maybe hasn't been brought to the board's attention, but perhaps might be worth looking into further, particularly with the issues that we have in the city right now happening against Latinos with the civil rights.
I'm sorry, this is Board Secretary Alvin speaking again. Mr. Watley's used up his 3 minutes allotted.
Great, thank you. I don't believe that we have more speakers in the queue. Again, I'm just getting used to this system. So I think it's time to move on to deliberation. And I believe, Steve, did you want to start off deliberation? I think you had a question, comment. Thank you.
I did. Thank you. I appreciate that. This is a question for council. I'm wondering what my concern is getting into the negotiations of contract with third parties. I don't see that as being, our jurisdiction. And what I fear is that this conversation is going a little, it's become a little overbroad with what we are here to see. As I understand, our job tonight, the board's job tonight, is to see whether we should grant the removal permit or not, and whether CCSM has met those requirements. While I know there may be some consequences one way or another between what agreement is agreed to or not agreed to, I think that's between the third parties. So my question to you, council, is, am I right that there should be a concern to be moved to a decision based upon the negotiations that are going on between the tenants and CCSM?
The only issue before the board is whether or not the application meets the criteria for a removal permit. So you're correct that these other issues are on the periphery and not part of your part of the criteria that you are applying.
Thank you. Then having heard that, I feel like they've met the criterion for the removal permit, and I'm ready to move on a vote. Obviously, I'm the first one speaking, so maybe there'll be more discussion, but that's kind of where I'm at. Thank you.
Thank you, Commissioner Duran. Commissioner Foster?
Thank you, Chair Sultan. So I just want to start by saying that I was one of the commissioners who voiced concern about moving ahead in the first time that we heard this case. And I'm still not sorry that I, for my part, advocated that we wait. At that time, it seemed potentially confusing and mired, and we perhaps didn't have the full picture spelled out that we were comfortable with. We have more than enough information in the time that has elapsed since, and I, for one, have serious concerns as to whether this has perhaps disclosed everything to these tenants or is further confusing the issue for these tenants. I find it deeply distressing to think that had this property not been purchased by CCSM but by some private developer, all three of these families would be out on the street at $17,000. Not the six-figure plus sums that were calculated and offered by CCSM, not grandiosely larger accommodations in modern facilities that are being provided by CCSM, moving expenses covered, inconvenience fees provided by CCSM. And if CCSM has had chinks in the armor of this process revealed to them by this process. I think that's a good thing for them and for future tenants in other buildings they might feel the need to rescue from private development. I think it's unfortunate that families' lives had to be disrupted in any of these 3 units, and I do understand that fear and how that feels. But it is not my place as a rent board commissioner to worry about things that are outside of our jurisdiction, and I don't plan on doing so here tonight. As a tenant advocate in my private life, do I feel strongly about it? I do, and that's why I, as one of 5 voices, requested that we give this a more thorough vetting before we understood the removal process in this particular case. We've heard it, and like Commissioner Duran, I'm also prepared to move forward after other commissioners have had their say.
Thank you. Commissioner Torroses?
Great. I actually am wondering if anyone from Community Core is still on the line.
Hi, this is Jesus here, and our counsel is still here, and so is our relocation consultant. So we're here to answer anything else that you may have.
I have a question for Ms. McClintock, if that's okay, if you're still there, Ms. McClintock. I'm wondering.
Absolutely.
Great. I'm wondering if you've discussed this conditional removal permit with opposing counsel before, if this is the first time that it's being brought up. And then I'm also, second part of that question is, if we were to grant the removal permit, I assume that is your preference in order to move the project forward, rather than not granting it so that the agreement could be solidified. I know you said there was material terms that were agreed to, but it sounds like opposing counsel saying that they weren't. So sorry if that was meandering. Was that clear on my 2 questions?
Yes, absolutely. As for the first question, no, we had not discussed a possible conditional grant with opposing counsel, or it has not been asserted prior to this meeting, at least with me at this point. And 2, yes, it would be our preference for a grant, but I, having been a litigator prior to my transactional role now, I don't want any additional litigation, nor do I want that brought upon my client. And while I do believe it is a bit of a strong-arm, bad faith tactic to put the board and CCSM in this position right now, and I think that counsel, even with a grant, counsel could wait to file any lawsuits since we are so close to agreeing. That being said, CCSM, we have the same goals of getting to the agreement to relocate. So if the board is entertaining a conditional grant, we can work with that as fine as staff can finalize the permit removal approval.
Great. And I'm sorry, I think I mispronounced your name. Thank you, Ms. McClintock.
You got it. Yeah, no problem.
Okay, so that answered my questions. Naomi, I just want to, Chair Sultan, I want to finish my comments if that's okay. I wanted to get that out of the way. Is that okay?
Yes.
Yeah, so I have, no surprise, pretty similar thoughts to Commissioner Foster, because I think that's the reasonable thing here. Look, we were not required to delay this. I believe, had the that CCSM had met the requirements, like strictly speaking, letter of the law requirements for a removal permit last time they appeared before us. However, all of us here to protect the tenants wanted to ensure that everything was above board, and that as it was mentioned, non-English speaking tenants could have gotten confused if all of these agreements were in English. There were legitimate questions, and as a courtesy, and as a way to ensure that the tenants were fully protected, we asked for a return. I feel that in the intervening time, I feel very confident in what has transpired. I feel confident that we are going to get 48 newly constructed 100% affordable units. I feel very confident that we are going to get a 1-for-1 replacement on the rent-controlled units that are being demolished. And I think that as someone who lives in this neighborhood, I think it's going to be great. It's going to be fantastic for our neighborhood and also for these tenants. And so I would absolutely hate to see us lose these tax credits because I know how competitive they are to get, especially specifically the 9% tax credits. This is a great project. And I think that I almost feel as though we're being held hostage tonight because we're being told that you're damned if you do and you're damned if you don't. And so I'm inclined to grant the removal permit. I think the criteria have been satisfied. I really don't like the feeling of being, held hostage in this manner at the 11th hour. I think everyone's operating in good faith here, and everyone has the best interest of the tenants in mind. And that's what, I feel very confident that CCSM has demonstrated. So I'm prepared to move forward. Thanks.
I'll make a motion if nobody else wants to comment. Chair?
Yeah, sure. Please.
Because I feel CCSM has met and indeed exceeded the charter's requirements for a removal permit, I move that we grant the removal permit and adopt the proposed findings of fact and conclusions of law.
Do we have a second for that motion?
Second.
I'll second.
Oh.
Looks like we have a second. Commissioner Terosas.
That's fine.
Or, sorry. Okay. Well, you'll get to vote, Steve.
Thanks.
Can we take a roll call vote then?
Yes.
Mr.
Okay. Commissioner Foster.
Yes.
Commissioner Terosas.
Yes.
Commissioner Phyllis.
Yes, sorry.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
Great, thank you. Hold on one moment. Stay tuned. Okay. Now we will, let's see, we had a jurisdictional item that was continued to next week, so we're going to move on to administrative items. We have Mr. Brian Augusta here, our board advocate and representative in Santa Monica. And he is going to tell us what's been going on in Sacramento with the recent tenant relief legislation. So welcome, Mr. Augusta.
Hold on, Chair. Wait, before Mr. Augusta talks, and by the way, Mr. Augusta, you're on mute. I think we missed, unless I'm an idiot, didn't we miss 10A, the appeal? Or did that get...
It was moved to next month.
I'm an idiot, sorry.
Yes, I believe that was continued, so Mr. Augusta, thank you.
But Carolyn, you're not an idiot.
Yes, you're not an idiot. I have it right here. That's how I know.
I have all this stuff ready to go, but that's okay because I would definitely love to hear from Mr. Augusta.
Well, thank you, Madam Chair and members. Brian Augusta, your advocate in Sacramento. Always a pleasure to have the opportunity to address the board. Before I get into my remarks, I want to echo Ms. Condon's remarks a moment ago and just note how pleased I am to see Allison Regan up on the virtual dais tonight. I've had the pleasure of working with her in her prior position and have been always 100% impressed with her professionalism and command of the issues. And I think the board is going to be well served by her wise counsel and its constituents. So Allison, I look forward to continuing to work with you in your new role. So tonight I wanted to talk a little bit. This is unusual that I'm here this early presenting to the board. Usually I come sometime in April or May after we've seen all the bills that have been introduced and a little bit of action on those bills. But this is a somewhat unusual circumstance in a variety of ways, most notably that we, in addition to the changing circumstances of COVID, we also have this very rare instance where we have a new piece of legislation that is that has been made public and enacted in a matter of days and taken effect in January, which is something that almost never happens. And the reason for that is that we had a prior piece of legislation, AB 3088, which had established some protections against eviction, which would have expired at the end of January, had the legislature not acted. So I will be back to address the board a little bit later this year to talk about additional legislation. I know there will be questions about a couple bills that have already been introduced, and I'm prepared to talk about those as well. But the main thrust of my presentation tonight is about SB 91, which is the legislation that just recently passed. And, a high-level overview of it. Also want to hear questions from the board, and I'm sure there will be comments as well. I'm going to provide just a short PowerPoint presentation. Hopefully it's while I'm waiting for my computer to cooperate. Oh, there we go. Okay. Hopefully everyone can see the presentation now. So I want to just give us a quick overview of where we are in the legislative session and then talk in a little detail about SB 91. So where are we in the legislative session? Next Friday is the introduction deadline, and between now and then, we're beginning to see bills trickle in. Between now and then, we will see probably a flood of new legislation, including many housing and landlord-tenant related bills. We also are in this unusual circumstance where we have some additional federal dollars that are coming down. We have an unexpectedly large general fund surplus in the state general fund. And so we're going to see some early budget action and probably throughout the legislative calendar going into the typical May revise of the budget and into June, some additional, obviously budget allocations, but also, potentially some sort of policy making related to those budget allocations going into June. Then we will move back into sort of the policy making process through the end of August. Then we will see most bills have moved all the way through to the governor. We'll have 30 days to sign, and then we will repeat that process in the second half of the year. The unique thing about this year is that once again we know we're going to be in a time period in which we are subject to limitations, COVID, and that will mean most of the policymaking and lobbying and advocacy and public participation will occur primarily remotely, which not only provides a lot of challenges for those of us and members of the public who are seeking to engage, but it also slows everything down because that process, while it provides for some additional public input that might traditionally not have been allowed because you would have to have driven to Sacramento for that, it does make for a slower process. So the result of that is that we will probably see fewer bills moving, and both houses have cautioned their members, both Senate and Assembly, to be very judicious in the number of bills that they introduce and to expect that only a handful of them will move. So even as we start this process with what will probably be a flood of bills, I think we will see a quick winnowing, as we did last year, of those bills to the ones that are of most urgency. As we move into that process, we have this very unique circumstance, SB 91, the follow-on to AB 3088. As I mentioned, AB 3088 was enacted at the end of last session to replace or to provide a stopgap after the Judicial Council repealed its emergency rule that had put most eviction actions on hold. And so 3088 provided some protections, but that bill expired at the end of January. And so it was urgent that something replace it now. A number of tenant advocates had sponsored AB 15, which was introduced by Assemblymember Chu, part of a package of bills to address the eviction and debt crisis that tenants are facing. But that bill was not the vehicle, and the issues in that bill did not necessarily make it into the final legislation. Instead, what became SB 91 was negotiated largely behind closed doors. I don't think anyone could take issue with that characterization. This is not unusual. We've seen this in other circumstances. Much of what ended up being the dissolution of redevelopment, energy deregulation, some prison reform, a number of other issues have been largely developed with sort of the big three or big five, that is the leadership of both houses and the governor, negotiating things behind closed doors and then putting it out publicly for a vote with very little time for input. And often that's done with a purpose, and the purpose is to foreclose a lot of lobbying and other advocacy that might result in the bill changing or not moving, and that's what happened here. So those of us who are working diligently on trying to advance what we think were the important provisions to both expand AB 3088 and also address the looming debt and eviction crisis, were not really part of those discussions. There was a short time period at the end, some opportunity for the bill to be shaped a bit, but it mostly went through in its final form fairly quickly, without a lot of public comment, and in large part because there was a deadline to be met. So that being the process, let's talk about what's there and what's not there. The bill extends AB 3088's eviction protections to June 30th, 2021. So that means that tenants who sign a declaration asserting COVID impacts, who aren't able to pay the rent, cannot be evicted before June 30th, 2021. And if they pay at least 25% of the rent that is owed, they can never be evicted for not paying the remainder. The question that has been on everyone's mind about that, and continues to be, is what happens to that other 75% of the rent. And SB 91 answers that question in part by setting up a system by which I'll talk about in a moment, deploy the $2.6 billion that has been provided in rental assistance to the state by the feds. But in addition to extending 3088's eviction protections, the bill did a number of things. It put a pause on most collection actions. So it plugged one hole in 3088, which is that it stops the filing and puts on hold most actions to collect that debt in a civil case. Under 3088, that protection only was placed for small claims court actions. So some landlords were going to limited or unlimited civil court and seeking to collect on the debt, even though the tenant could not be evicted for it. But this puts a pause on that. It also closes another loophole, which is that in many instances, that debt can be sold to a third party or assigned to a third party who can start collection actions immediately. The bill prohibits the sale or assignment of debt at least until June 30th. It also establishes new limits on late fees and limits on reducing services or increasing other fees. It protects tenants from misapplication of rental payments, which essentially ensures that if a tenant pays the rent for the current month, it's not applied in a way to a prior debt that would put them at risk of being immediately evicted. And it prohibits the use of COVID rental debt. Usually a default in the rent will end up being on the tenant's credit report at some point. This prohibits the use of that COVID rental debt to deny tenants housing in the future. On the substance of the deployment of the resources, at the very end of the year, we saw passage of $2.6 billion, well, larger than that, but the portion that came to California, $2.6 billion in rental relief, which we must deploy quickly. It has two sort of tranches, if you will. One that goes to the state, about $1.1 no, sorry, 1.5 goes directly to the state, and 1.1 of the remainder, 1.1 goes to individual jurisdictions above 200,000 in population. And there, under SB 91, there are several options for these entitlement jurisdictions, of which LA City and LA County are entitlement jurisdictions. Santa Monica is not. So they get the city and county of LA get a direct allocation. And they have three choices under this legislation. They can take a portion of the state's money that would be otherwise eligible for residents of let's say LA County and manage that money and their own entitlement together. Or they could take their entitlement money and give it to the state and let the state administer both portions. Or they can opt out of taking the state money, administer their own money, and let the state administer the portion that would otherwise come to the local government. Every city and county needs to make that choice, who's an entitlement jurisdiction, by this Friday. So we're going to know a lot after tomorrow about who's in, who's out, which choices have been made. But if the state, if they choose the state option, take the state money and let the state implement it, the state is going to be implementing the money through a third party, CDFI, who is one of the largest in the United States, who has experience in how to swiftly roll out that money. If they administer it themselves, it's obviously going to be up to the local jurisdiction, but in either of those cases, there'd be one point of contact. If it's bifurcated, there'll be 2 points of contact, and one of the issues that is being discussed is how do you ensure that tenants or landlords do not try to access both programs for the same debt. So there's trade-offs to both. There are a lot of people who are concerned about the implications of having to, I think I didn't say this, but if you take the state money as a local jurisdiction, you're subject to the state rules. So that is one reason that some local governments, Orange County is one of them, has chosen to opt out. They can write their own rules for the money that they got directly. So what does the rental assistance cover? Well, if a landlord who has a tenant who is eligible applies, they will get 80% of the rental debt for that time period from April 1st through June, April 1st through March. And if not, then they will then the state, if the landlord does not apply, if they apply the 80%, and they have to waive the additional 20% that the tenant would otherwise owe. So wiping all that debt out. If they choose not to apply, it's the tenant can apply and get 25% of the rent that is owed in a direct payment. Now that is important because that means that they will have enough money to avoid the cliff in June if they can't pay the rent. Who is eligible? Households making at least 80% or making no more than 80% of the median household income from the county, with a priority for those at 50%. Now, one other important thing is we're talking about rental debt that's accrued up till now. What do you do about the rental debt going forward? The program also will allow for a 25% rental payment going forward, so at least providing the minimum to, again, avoid that rental debt. But the looming question is what becomes of that new debt in June, the amount that's accrued between now and June, that's 75% potentially. A lot of people are looking to additional money that we expect to come down from the Biden administration and some additional policy making that will address how we're going to erase that debt and deal with the next sort of looming eviction and debt cliff. I mentioned that the state program is going to be administered by a CDFI. They expect to have it up by March 15th, so it's a very, very short timeline. Let me pause there for a moment. I do want to, actually maybe I'll address, why don't I pause on that since I see that at least one commissioner has her hand up. Madam Chair, would you like me to continue the presentation or just take questions on this part for now?
It looks like Commissioner Tarosis has a question, so let's go with that, and then maybe you can resume.
Yeah, no, just because I know that SB 91 is so extensive, and I'm sure that's probably the chunk of the highlight or the update. So, Brian, thanks for that, explanation. And obviously, I, like many others, am very concerned about the equitable allocation of the funding statewide and how this was determined. I think that we obviously need to be prioritizing jurisdictions that have been the hardest hit by COVID, by a lack of housing crisis and an overcrowding issue that we have here, as well as the fact that we, have a huge homeless crisis and more people flowing into homelessness every day during COVID. So I guess my question to you is, tell us about, how this is going to affect Santa Monica. We're just going to get the straight state allocation, no choice, have to follow the state rules. Isn't that right?
Yeah, well, so
the size of our city.
I'm sorry, say that last part again.
That's due to the size of our city, correct?
Right. So you won't get a direct allocation. You'll be part of the county's allocation, correct? And so that money will, now on the equitable distribution of those funds, there is a formula, which please don't test my command of it, but there is a formula that will help determine that money would be geographically distributed appropriately in terms of population count. But there's a secondary question, right? Which is how does the money get sent such that we're actually matching where the need is the greatest? And
exactly.
Yeah. And so the architects of this, which are primarily folks at BCSH at the agency, assure the public that they will be making monthly assessments of how the money is being deployed and making sure that it is meeting those sort of equitable guidelines. But that is obviously a huge issue of how the program gets rolled out, which we're all watching closely because the legislation was only enacted, weeks ago, and they're standing up this program in the next 3 to 4 weeks. And so there's undoubtedly going to be a lot sort of change that's going to be necessary as we see how it actually happens in real time. But they are, they built into it some monthly assessments of that they assert will help them make those adjustments. And I think that's where a lot of advocates, and it sounds like this commission is deeply concerned and will be watching closely. And I think the real question is, is the state prepared to change course if and when we see that it's not rolling out?
Yeah. Thanks, Brian. I know that, people were working hard to try to make something happen, and clearly something is better than nothing in terms of making sure that we're staving off this eviction tsunami. But I really do see this as kicking the can down the road. I don't think that, it's a sufficient amount of money. It seems like it's been put together quite quickly, in a little bit of a haphazard way. The fact that you would have to be going to multiple administrators, and again, I'm very concerned about equity. Population size is not the correct way to go here. We know that, COVID has hit communities of color harder. We know that it's hit places with multi-generational households living in one house harder, and therefore places with a housing crisis have been hit harder, epicenter LA County. So I just want to make sure that in Santa Monica that you advocate for us to get our highest proportionate amount that we possibly can. It doesn't sound like we really are going to have much option, but if there isn't a need to course correct, I would hope that you could, quickly advocate on our constituents' behalf, because I'm extremely concerned and disappointed in the governor's administration for pushing this forward. Thanks.
Thank you.
Thank you, and I echo what Carolyn said. Thank you for a really thorough and concise and simple explanation of what 91 does and doesn't do. I don't know if you were going to cover SB 9 and 10 after these comments, but I want to take a moment to consider that other than wonderful people like you and Anya Lawler and Western Center on Law and Poverty and groups that work full-time on these issues, most advocates are working part-time. We have day jobs and we do other things, but the industry works on this full-time. And I often sit back and start seeing connections between things like what SB 91 doesn't do, and then SB 9 and 10. So a colleague recently pointed out to me that not necessarily just in Santa Monica, but all over our region, which affects real estate pressures on renters here in Santa Monica, you might have, after the mortgage crisis of 10 years ago, tenants renting back the houses they used to own. And with problems with Costa-Hawkins exempting single-family homes, even for large multiple corporate owners and things like that, then I start seeing overlap between the desire to be able not to participate in the program if they don't want to, and collect on these people and get them out and then redevelop the properties under SB 9 and 10, for instance. It really is all related, and it happens way too quickly in Sacramento. And like Commissioner Trosas, I'm deeply troubled by Democrats' seeming willingness to work nonstop for these other forces and not for the vast majority of their constituents who happen to be tenants. It's not fair, and it's not equitable. And I do see a connection between these other bills and all of this, and I want to know if you also see that.
That question is directed to me, right? Yes, I think that's an excellent analysis, and I do want to just mention, in the last slide I was going to talk about a few bills, but I was mainly going to mention. I won't pull that slide up because then I can't gauge exactly how bored everyone is by my presentation because I can't see anyone's faces. So I will just say
we're not bored.
So SB 9 and 10 are two bills that are a replay of bills from last year. One by Senator Wiener would allow for units of for local governments to adopt a policy that essentially allows up to 10 units on a given parcel and make that ministerial. The Atkins bill, again, a replay from last year, would do something similar with respect to lot splits and allowing 2 units on a single family lot. The Atkins bill does have some language in there that advocates have pushed for before that protects it from, makes it inapplicable to a site that, among other things, had been Ellised or has a rent-controlled unit or tenants in place prior to it, but the Wiener bill does not have that feature. So there is an ongoing debate in Sacramento about what the implications are of these state-mandated overrides of local discretion over development, and whether or not the right balance has been struck between creating more opportunities for additional housing and ensuring that the housing that we're creating is meeting the needs of the local community, which in many jurisdictions is highly tilted towards low and very low income folks, and many of these proposals don't have any limitations that ensure that. So that's part of the debate. We've been engaged in that debate in Sacramento and expect we will be again this year on those bills and others that are looking to do that. So always helpful to hear your direction and your insight on that because it helps guide our advocacy on your behalf.
Fix Costa-Hawkins. There. I said
it. Yeah, I mean, my direction. Sorry, are you done, Brian?
Yes, thank you.
I think we have to see 9 and 10 be negotiated. I know that our city council just took an opposed position. I don't want to be classified as someone who's trying to stand in the way of building more housing in the right places and near transit. I'm just still very concerned, as I always am, about these anti-displacement protections and making sure that we're protecting our most vulnerable. And I don't want this to be, an excuse for a demolition derby with lots of, luxury multi-units. So I can't say that I'm giving direction on those at this point. I'd like to see what happens. But really what I'd like to see the most is more money allocated for our struggling renters, our affordable housing stock, our homeless crisis. We continue to fixate. I know that zoning is part of the problem, but we have a Costa-Hawkins problem, we have an Ellis problem, we have other issues that I feel are a little bit, more germane to the work of the board. So anyway, but thank you. And of course I could talk about, legislation all day, but I'll stop.
You and me both. I mean, if the commissioners want to listen to us talk, I suppose we could.
Well, I, for one, enjoy it. And I was going to say that I agree with what Commissioner Teros's, everything she said, and also Commissioner Foster. But yes, obviously equity is a huge concern for me. Also, doing the work that I do in representing people with disabilities, there's concern that landlords will choose not to, accept the 80% for tenants that have disabilities, because due to discrimination, and that those folks will end up losing their housing or owing the, additional money that the tenants, maybe tenants who aren't disabled, who may or may not be in, who may or may not be, paying higher rents or whatnot, they'll be disproportionately impacted by the evictions when they start happening. And if not eviction, then this increased debt that they'll have. But yes, definitely we need to make sure that all these apartments that are going to be built in any jurisdictions that were previously single family only are rent controlled. And to do that, we're going to have to, make some significant changes to state law, including Costa-Hawkins. Any other comments from the board or questions for Mr. Augusta?
I guess I would just say one last thing. I know that we sometimes take positions as a board on legislation. I don't know that we're there at this point yet. But just for staff, I would say that I'm also interested in SB 6 by Caballero, which I don't think Brian talked about, right, Brian?
Right.
Yeah, and that's using housing in sites that are designated for commercial use, and I think that that's something just in my other economic development work, interesting trend to look at, not only commercial but industrial uses, and how we can look at land use as a way to create more housing opportunities, I think is important. I know that's what SB 9 and 10 are doing, but are there ways that we can rezone? So I'm kind of interested in that. And then I'm also interested in SB 5 by Atkins and also and then AB 71. Just in terms of generating funding, because as Brian mentioned, we don't have enough funding for housing, especially with the dissolution of redevelopment. So SB 5 and AB 71 would be two others. Yeah, just for
I'd add SB 15 to that list.
And SB 15. Can I just note for the commission as well that you mentioned, Commissioner, that the Caballero bill, but Assemblymember Bloom has AB 115. Both members had, which does a similar thing about permitting residential and commercial. Mr. Bloom's bill last year had an affordability component. Caballero's did not. This year both do. But so, as we come back and you look at positions on bills, I want to make sure you're looking at both of those because they're both sort of entries in that area.
You said 115, 115?
Yeah, 115.
Yeah, thanks for asking. I would always love to support a Bloom bill before all others.
Yeah, and we will, I believe, we'll be coming back for a presentation, and that will have a full list of bills, so we have something more to consider between now and then.
Thank you, Brian.
Thank you so much. It was so important.
Thank you, guys.
We'll look forward to having you back in person soon.
I hope so. I would love that. Thank you all.
Thank you, Brian.
Hey, so I believe we have made it through our agenda for tonight, unless I missed anything.
I'll move to adjourn.
Okay, great. Do we have a second on that?
Second.
Okay, great. Motion from Commissioner Phyllis, second from Commissioner Foster. Secretary Ho, can we take a vote, please?
Yes. Commissioner Foster,
Yes.
Commissioner Torosis,
Yes.
Commissioner Phyllis,
Yes.
Vice Chair Duran,
Yes.
and Chair Sultan.
Yes.
Motion carries.
Thank you, everyone.
Great.
Thank you.
Thanks,
Bye. Good night.
Thanks
Thank
for
you.
having us.
Good night.
Bye.
Good night, everyone.